Good morning, friends. In view of the recent controversies with regard to the independence of higher judiciary and the allegations of corruption, I would like to share my views on this subject under the title The Independence of Higher Judiciary, the Appointment of Judges, Lack of Transparency and Social Diversity, Corruption, affecting the very object of the Constitution. As all of us know well, the Constitution of India envisaged and established an independent higher judiciary free from the interference and influence of the executive or parliament, assuring the citizens of India about the safeguarding the constitutional mandate and their rights and liberties. In recent times, we have been regularly hearing and reading about the lack of transparency in the appointment of judges to the apex court, that is Supreme Court, and high courts under the present collegium system, and also the partisan attitude of certain judges in quid pro quo controversies for post-retirement benefits and political rehabilitation. We are also coming to know about the communal overtones of some of the high court and apex court judges favoring one section of ideology and obliging the government in power at the center, raising doubts about their integrity and adhering to their constitutional mandate and the way their appointments were made. Added to this, the recent sensational alleged corruption case of Justice Yashwant Verma, the senior judge of Delhi High Court, in whose official residence several checks or files of high-value currency notes has added to the growing concern of the people of India about the independence of the higher judiciary. The other aspect of the matter is that there is a growing concern among citizenry about the total lack of transparency and diversity in appointment of judges to the High Court and Supreme Court, reflecting the aspirations and giving representation to different sections of the society, more particularly the SC, ST, OBC minority classes in higher judiciary, giving the impression that it resulted in biased rulings in many cases, particularly to these classes. Further, there is also constant concern among the public that the corruption in higher judiciary is not being properly dealt with, and there is no proper mechanism to control the higher judiciary once the appointment is made on the pretext of ensuring independence. The internal mechanism for dealing with such cases shrouded in mystery, as in-house procedure was never made public in any cases. So also the process of taking disciplinary action by way of impeachment is a complex one. Coming to the appointments of the High Court and Supreme Court judges, the lack of transparency and social diversity is concerned. The government statement made on the floor of the Parliament about the appointments on 26/3/2025 by the Union Law Minister discloses that since 2018, out of 715 High Court judges appointed, only 22 belongs to SC community, that is 3%, and 16 belongs to ST community, that is 2%, and 89 belongs to OBC community, that is 12%, and 37 belongs to minorities, 5%, and 551 are from upper caste classes, that is 78% of the appointments are from upper caste classes. This is a clear proof of the lack of social diversity in the appointment of judges to the High Courts and Supreme Court. Even in the Supreme Court at present, the total strength is 33. In fact, the total strength must be 34. So only 2 from SC community, 1 from OBC community, and 1 from Muslim minority. The rest are from upper caste. Thus, out of total strength, the SC, ST, OBC minorities representation is dismal. This lack of social diversity and also the diversity in the appointments definitely impact on the functioning of the higher judiciary and also the rulings and judgments on various subjects involving the rights and interests of the marginalized communities. The Constitution of India provides the framework for appointments of judges to the Supreme Court under Article 121, judges to the High Courts under Article 217, and the transfer of High Court judges under Article 222. Under Article 124, the President of India appoints Chief Justice of India based on the seniority, and other judges under the collegium, other judges in consultation with the Chief Justice of India, and the senior Supreme Court judge under the collegium system, which gives primary role to the Chief Justice of India and senior judges in judicial appointments and transfers, reducing the executive interference in order to maintain the independence of judiciary. Under Article 217, the appointment of High Court judges will be done by the President of India after and in consultation with the Chief Justice of India, the Governor or the government of the concerned state, and the Chief Justice of respective High Courts of the state. Under Article 222, the transfer of judge from one court to another will be carried out by the President of India after and in consultation with the Chief Justice of India. However, there are serious doubts and also mounting criticism that this collegium system, which was evolved through the Supreme Court judgments in 1993 and 1998, as there is no clear selection process and criteria or public scrutiny, and the system often criticized as being opaque, and this process lacks institutional accountability. Since reasons for the selection or rejection of the candidate are not disclosed in detail in public domain, and the process largely closed to the public oversight. Under the collegium system, there is alarming underrepresentation of SC, STs, OBC, and minorities in the higher judiciary, which is a prime cause of concern. Unlike the reservation system in public employment, there is no formal method of reservation or giving equal weightage to these classes in higher judiciary appointments, and most of the judges are selected from a pool of advocates and High Court judges where the upper caste and privileged groups dominate, as clearly reflected in the numbers provided by the Law Minister in the recent reply. It is pertinent to recall that the first Dalit CJ, Chief Justice of India, was K.G. Balakrishnan, and thereafter a very few women, OBC and minority judges were appointed, which indicates only a snail and slow improvement in reflecting the diversity. The collegium system suffers from inherent defects, that is, lack of transparency in the appointments, as there is no clear-cut criteria for selection or rejection of the candidates for the appointment as judges of high courts, and the process of selection and the decisions of the collegium are never made public, and the reasons for appointing or not appointing a judge are not known, leading to suspicion and speculation about the process of selection and appointment. The other glaring defect in the collegium system is that there is no accountability, as the sitting judges decides the appointments without any external checks, and there is no oversight mechanism to scrutinize and review the appointments. The appointment of judges to the various high courts, if carefully observed, the appointment of judges to the various high courts, if carefully observed, it is visible that the system favors the judges' relatives, influential legal families, and senior advocates having proximity with the judges rather than the meritorious candidates. The other defect in the system is that the trial court advocates, however meritorious and experienced are, they are totally excluded from the consideration for selection and appointment as high court judges. The lack of structured selection process with transparency and representing the social diversity and different regions to reflect in the composition of high courts and their functioning, they allows subjectivity and bias to play a vital role in the selection and appointment. Many qualified candidates are simply rejected without any explanation, and sometimes the executive or the government is also kept in the dark as to why the names are dropped by the collegium. This system does not allow any oversight mechanism, that is parliament or executive, in the judicial appointments, and is totally a closed door selection. Other glaring defect in the system is complete lack of social and regional representation, as it failed to ensure proper representation to SCs, STs, OBC, and minority communities and women. And many states remain underrepresented in the Supreme Court and as well as in the High Courts. Added to this, in the recent years, the present central government, headed by Narendra Modi, has many a time interfered with appointment of judges, in spite of the fact that the power of selection is with the Supreme Court Collegium of Judges, and the government can only temporarily withhold or return the name of the judges selected by the Collegium. And though if the Collegium reiterates its choice, the government has no option and except to ratify and notify the appointment. But the present government has stymied the selection of independent judges by the Collegium by simply sitting on recommendations for years without any response. And if the said recommendations are not in tune with its line of thinking, and even when it forced to approve and notify the appointment sometimes, it still did not notify the appointments of many judges who are not considered considered inconvenient to it, and at the same time it notified the appointment of those judges with jet speed that towed their likes and dictates. As rightly pointed out by the senior advocate Sri Prashant Bhushan in the recent years, on several occasions, the collegium bowed to the pressure of Modi government and bent backwards by selecting some of the judges who are favored by the government or recommended by it, and this resulted in the appointment of many judges in the last 10 years who either committed to the Hindutva ideology or follow the dictates and wishes of the government, resulting in a substantial erosion of independence of the judiciary. The collegium system was evolved through the Supreme Court judgments in 1993 in the first judge's case and in 1998 in the second judge's case, which gives the Chief Justice of India and other senior judges called collegium a primary role in judicial appointments and transfers to the High Courts, reducing the executive or government or parliament interference with the premise that the judges of collegium will be impartial and within the constitutional mandate. However, there is growing impression that the system helped the higher judiciary to arrogate the power of appointment without any transparency and proper public scrutiny, and thereby degraded the court's independence. The government then brought the National Judicial Appointments Commission Act 2014, which is called the NJSC Act, by way of 99th constitutional amendment, which sought to replace the present collegium system with more transparent system, but the same was struck down in 2015 by the Supreme Court, citing the concerns over judicial independence. In fact, the NJSC envisaged the selection process of High Court and Supreme Court judges by constituting a committee consisting of Chief Justice of India as chairperson, two senior-most Supreme Court judges, Union Law Minister, and two eminent persons nominated by the Prime Minister, తర్వాత CJI and leader of opposition in Lok Sabha, and also recommended the appointments and transfers to ensure transparency, accountability, and diversity in judicial selection. And if any of the two NJSC members opposed a candidate, their appointment would be rejected. However, there was possibility of executive or government having upper hand with Union Law Minister and two nominees whose eligibility is not specifically mentioned being in the panel. The government may have upper hand, threatening the independence of judiciary, and the veto power would be misused by using it arbitrarily, blocking the deserving candidates, and there was a lack of sufficient safeguards, that is checks and balances, to prevent the executive government dominance over the judicial appointments. Basing on these defects, the Supreme Court struck down the NJSC Amendment Act 2014, and collegium system continues till the date. However, The collegium process is under controversy from time to time, without any transparency and accountability in selection and appointment of judges to the High Court, and there is no specific procedure. There is no specific procedure and scrutiny, and as such, the system is criticized for being opaque, and there is a gross underrepresentation of SC, ST, OBCs, and minorities, which is a matter of serious concern. And as such, the reforms are needed to make the process of appointments and transfer more transparent. Are needed more transparent, ensuring social diversity and accountability by creating a mechanism of wider consultation and more inclusive, and the collegium to function as an independent entity. With the recent controversies and episode of quid pro quo judgments by the Supreme Court just before their retirements and getting plum post, as in the case of Ranjan Gogoi, Arun Mishra, and Nazir Ahmad, and Abhijat Gangopadhyay of Calcutta High Court, who was given ticket after giving favor to the government and resigned just 5 months before retirement and elected as MP Lok Sabha. And with regard to the appointment of L.C. Victoria Gauri, who was active member of RSS and BJP and being National Secretary of Women Wing, and made violent speeches against minorities as a High Court judge, and Justice Shekhar Yadav of Allahabad High Court, who delivered a hate speech making comments against minority community by openly and attending the communal outfit. And the latest one is the discovery of piles of currency notes in the official residence of the sitting High Court Judge Yashwant Verma of Delhi High Court, which resulted in public furor and fear, and once again raising the concerns of the public about the independence of judiciary and mounting corruption. It is not out of place to mention that during the 2017, a sitting judge, Kurnool, pointed out about the growing corruption in the higher judiciary, for which he was not only removed from the post but also jailed because he was from depressed classes. But whereas so far no action has been taken against the judges cited above by the Supreme Court Collegium, who belongs to upper caste, which again a cause of concern, as there is a selective dealing of cases of delinquent judges by the Supreme Court, which calls for a thorough overhaul of the present collegium system. It is a welcome gesture from the Honorable Supreme Court and Honorable Chief Justice of India, Justice Sanjeev Khanna, who opened the case of Justice Yashwant Verma to the scrutiny of the public by disclosing the inquiry report and also video clippings, and further, the Supreme Court headed by him has taken a positive decision to disclose their declaration of their assets to the public and posting them in the Supreme Court official website to instill confidence in the public. The present government has repeatedly interfered with appointment of judges, though the government only can return the appointments made by selected by the collegium once. But if the collegium reiterates its choice, the government has no option except to notify the appointment. But Modi government has timed the selection of independent judges by the collegium by sitting on the recommendations for the year without any response and without notifying the appointments. But whereas in case of likes of L.C. Victoria Gauri, it acted with jet speed and notified her appointment within 24 hours. Even when it is forced to respond, it returned with objections. But thereafter, though it is unanimously reiterated by the collegium, it is still not notified the appointments of many judges who are considered independent and inconvenient to them, while quickly notifying the appointment of those judges that toes their line and ideology. Unfortunately, in recent times, on several occasions, the collegium also has went backward to appease the government by selecting some of the judges favored by the government. And with these controversies of Justice Verma, the government appears to be trying to take an advantage of the situation and fish in the troubled waters of the judiciary to retake the control of the power of appointment and the transfer of the judges, as the way in which the Vice President of India and Chairman of Rajya Sabha, Jagdeep Dhankar, took initiative to discuss the issue of National Judicial Appointments Commission Act with all the opposition leaders to bring back it to the fore. Though in the normal course it does not even allow the opposition members to talk in the debates and shuts them down by making caustic comments. Using the Justice Verma's case, it seems government is seeking to gain control over the appointment and transfers of the judges, which will be a death knell to the independence of judiciary, which is already hanging in a precarious condition. As we know well that the present government misusing all statutory institutions and constitutional bodies, enforcement agencies, and bulldozing the rule of law. And in these circumstances, if the government succeeds in its attempts to gain control over the higher judiciary, that will be a dangerous development. Therefore, it is essential and incumbent upon the opposition parties, people at large, legal fraternity, and civil society to see through the game plan of the government and resist any such attempts by the government. Then what are the possible solutions? Under the circumstances, what is the way forward to maintain and uphold the independence of judiciary by ensuring transparency, accountability, and representing social diversity? It is necessary that there should be a satisfactory mechanism not only in the appointment of judges, but there must be mechanism like the NJAAC, that is National Judicial Appointments and Accountability Commission, to ensure the transparency, accountability, and social diversity, as admittedly the present collegium system has largely failed to ensure these requirements. If collegium system continues, what is the need for reformation? So reformation in the collegium system with wider representation is one of the way outs, by making it more inclusive, transparent, and accountable, by including the eminent jurists and legal practitioners, bar council representatives, academicians from different social backgrounds, ensuring broader representation in the collegium, representing the social and regional diversity of the country, and by formulating a clear-cut and transparent criteria-based selection process, stipulating the qualifications of the candidates and the process of selection and appointment and the reasons for the selection or rejection, and making it public, including posting in the official website of the Supreme Court, so that the public will come to know about the appointment of judges to the higher judiciary and to ensure their merit and independence. Then, as far as the Corruption Act aspect is concerned, to tackle with this issue of corruption, the present impeachment method provided by the Constitution has not been found practical or desirable, as it required the signatures of as many as 100 members of the Parliament to begin with, and finally ends with a vote in both houses of the Parliament, which may have political overtones, and as such, so far no judge has been successfully impeached in the history of independent India, though there is much corruption in the higher judiciary, as the allegation goes. To tackle this issue of corruption, there must be a Judicial Complaints Commission consisting of 5 to 7 persons, including women who are independent of the government and as well as the judiciary. The said commission can receive complaints from the public against the judges of the higher judiciary, and if they find any prima facie case, they can put the issue for investigation and hold the trial of the concerned judge by another committee on par with the Judges Inquiry Committee, subject to the judicial review in exceptional cases. And the interference of the executive or parliament must be totally excluded. And this may tackle the problem of judicial corruption and misconduct to a greater extent. Then what about enacting National Judicial Appointments and Accountability Act alternatively? The alternative one is to bring a new act by way of amendment to the Constitution by making necessary corrections to the repealed NJAC Act 2014 with necessary safeguards without executive, that is government control, to balance the transparency and judicial independence, and that may be renamed as a National Judicial Appointments and Accountability Commission Act. The law minister must be excluded from the composition of NJAAC and replace him or her with a retired Supreme Court judge or a constitutional expert from the legal fraternity. The restructured NJAAC must have CJI as chairperson, two senior-most Supreme Court judges, one retired Supreme Court judge, and two eminent persons nominated and selected by neutral independent body, a senior member from legal profession, and one representative of the Bar Council of India to ensure the proper perspective of practicing lawyers as well. Then secondly, there must be a clear merit-based selection criteria reflecting the social diversity, merits, judicial experience and integrity and their past experience and the knowledge of the constitution and their contributions to the jurisprudence, and the set criteria must be published to make the selection transparent and challengeable, and also public disclosing the names of the selected candidates along with reasons, and maintain a record of this process without compromising national security and allow public scrutiny of the same. Further, it is desirable to allow the Parliament to review NJAA's recommendations only in exceptional cases, that too for procedural compliance and not with any ideological bias. And any objection by the Parliament must be referred back to the NJAAC for reconsideration and take final decision without allowing political override. This way, the NJAAC can function as an independent, fair, transparent and reflecting the social and regional diversities and free from political interference. So let us hope that the Supreme Court, the political system, the political parties, the legal fraternity, constitutional and democratic forces and civil society will arise to the occasion and to take up this important task and responsibility to ensure the judicial independence, transparency, accountability and social diversity in the higher judiciary by making the powers that be to act accordingly and to take necessary legal and constitutional measures at an early date before it is too late. Jai Bhim, Jai Bharat.